Good morning. Good government, accountability, and transparency are all laudable goals. But as the committee considers many of the proposals before it today, I can't help but think of the words that the late Justice Antonin Scalia wrote more than 30 years ago. When the Supreme Court was asked to consider the constitutionality of the independent counsel provisions of the Ethics in Government Act of 1978, which allowed for the appointment of an independent counsel to investigate and to prosecute certain high-ranking government officials, Justice Scalia, in a lone dissent, said, quote, "Frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. But this wolf comes as a wolf." So too today, there are wolves lurking among the proposals presented for this committee's consideration. As with so many things in life, the goals are good, but the devil is in the details. So when examining these details, I encourage the committee members to keep in mind two overarching considerations, one legal and one practical. Simply put, they're these: that each member of the committee has an independent duty to assure themselves of the constitutionality of each proposed reform and to ensure that each reform actually promotes good government. So let's start with the constitutional. It's undisputed that our founding fathers created a system of government with checks and balances. In James Madison's famous words, ambition must be made to counteract ambition. Unless you think this is some abstract idea without any impact on our day-to-day lives, it's this separation of powers, these checks and balances, that help ensure all of our other liberties. Now, you may be saying, fair enough, we agree, but what does this have to do with the proposals before the committee? Well, one proposal, for example, would make inspectors general removable only for cause. Even a recent CRS report, which examined this issue and examined the constitutionality of it, said it could be constitutionally questionable to place for-cause removal restrictions on certain IGs who would be impermissibly insulated from presidential control by multiple layers of removal protections. The current bill doesn't reflect this concern, and at a minimum, it should. But more to the point, given the uncertainty and the separation of powers concerns, would the potential damage to a foundation principle of our system of government be worth any corresponding benefits? After all, inspectors general are not the only mechanism that Congress has for combating fraud, waste, and abuse, or for seeking to put good government on a firmer footing. Congress can conduct oversight hearings, it can subpoena witnesses to appear before it, it can receive whistleblower complaints, and most importantly, it can even control the power of the purse. Then there's the broader concern that many of these proposals are meant to look good without actually accomplishing much in the way of substantive change. In that way, some of these proposals can actually do more harm than good for two reasons. First, the bills would place new responsibilities on government personnel, including IG personnel, without providing additional resources to carry out their functions. It sets them up for failure. And second, many of these bills deceive the public into believing these proposals tackle pressing concerns, when in fact they simply give the appearance of taking action against real or perceived problems. Then, of course, there's concerns about the law of unintended consequences. One proposal today that seeks to combat whistleblower retaliation would add to the list of prohibited practices the opening of any investigations as a result of a protected disclosure. It's a noble goal, but it doesn't take much imagination to see how this could be manipulated in everyday practice. Now, although this may seem far-fetched, I have experience with this. Early in my career as an assistant United States attorney, I handled civil litigation on behalf of the United States, including employment litigation. And it wasn't uncommon for problematic employees who expected they would be disciplined to file equal opportunity complaints, whistleblower complaints, union grievances, or some combination of those in efforts to set up a retaliation claim for whenever their employer took action against them. By engaging in such tactics, the problematic employee's underlying issues often went unaddressed, and it created a chilling effect for the supervisor to address the conduct of other problematic employees too. Of course, this isn't to suggest that every whistleblower or even most whistleblowers have performance or conduct issues. Many come forward for noble reasons and should be applauded. But we must be honest about the current system's shortcomings, which can have an equally pernicious effect on good government and accountability. And in closing, while my testimony today may be interpreted by some as offering a slightly discordant note, that's not my intention. I share this committee's desire to improve government accountability and transparency, but just as we should demand that government officials perform their duties in an ethical manner, we must ensure that any oversight of their conduct complies with the Constitution, actually promotes good governmental policy, and avoids to the maximum extent possible the law of unintended consequences. Thank you for this opportunity to testify. I welcome your questions.